Good morning, ladies and gentlemen. Welcome to the Supreme Court of Kenya for the hearing of Presidential Election Petition number 5 of 2022, as consolidated with petitions number 1, 2, 3, 4, 7, and 8 of 2022, the Honorable Laila Amolo Odinga and 7 others versus the Honorable William Luto and others. The Ready Chief Justice will preside.
Thank you very much, our court assistant. Good morning, Learned Council and the parties, distinguished ladies and gentlemen present this morning. We finalized the pretrial issues this morning, and on behalf of the 7 justices of the Supreme Court, we welcome you to this morning's proceedings. We have a tight schedule. Therefore, without much ado, we will ask the petitioner to start their case. But we will take the appearances. The quorum sheet, I believe, has been found, but we can take the appearances.
My Lady, the Chief Justice and the President of the Court and members of the Court, for the first and second petitioner, my name is James Orengo. I appear with my learned counsel, senior counsel, Firoz Noroji, together with my learned friends, Mr. Paul Mwangi and Ms. Julie Soweto. We also appear with senior counsel, Mr. Philip Murgor, is not in the court, but once I've concluded my submissions, he'll come in to continue to deal with an aspect of our case.
May it please Your Ladyship, Chief Justice, Your Ladyships, my lords, for the first and second respondents, the appearance is as follows. My name is Ngatia. I appear together with my learned friend, Kioko Kilukumi, Senior Counsel, Mr. Kirago Kimani, Senior Counsel, and Professor Kindiki. That is the team representing the first and second respondents. Thank you.
Madam Chief Justice and the Honorable Judges of this court, my name is Githu Muigai. I appear for IEBC and the second Mr. Wafula Chebukati. Jointly, I lead that team. The team for IEBC is Eric Gumbo, George Murugu, Dr. Willie Mutumbwa, Mr. Wekesa Simiu, Mr. Wambua Kilonzo, Mr. Moni Mukele, Mr. Mwangi Kibicho, Mr. Peter Wanyama, Miss Maggie Ngetich, Mr. Emmanuel Wetangula, and Miss Mase Mwinzi. The team for Mr. Wafula Chebukati is Abdikadir Mohammed, Senior Counsel, Kamau Karori, Senior Counsel, Michael Mushemi, Mr. Tito Tiego, George Gilbert, Collins Bush, Herman Omiti, Nancy Kangede, Moses Kipkogei, Innocent Muganda, and Mahat Jomen. Thank you very much.
Chief Justice, Deputy Chief Justice, Your Ladyship, my Lords, Justices of the Supreme Court, Paul Muite, in terms of the orders of this Honorable Court yesterday, Issa and I, in addition to the lawyer counsel on record for the 5th respondent, the 6th respondent, 7th respondent, and 8th respondent. In summary, the 4 commissioners, in addition to the respective counsel appearing for them, we've agreed in terms of the orders of this court that Issa and I will act collectively for the 4 commissioners whose views need to be heard. I need to add, for the sake of clarity, that we are not asking for any extra time. We will address this Honorable Court on behalf of those 4 commissioners by sharing time with the individual counsel for each of the commissioners. I thank you.
Your Ladyship, Madam Chief Justice, Deputy Chief Justice, and Judges of Appeal, for the 5th petitioners, I appear together with Lydia Mwalimu and Millie Odhiambo, not in court. Okiya Omtata will appear in person. I think that is in order. My name is Professor Tom Ojenda, Senior Counsel, just for record so that I don't come back.
Your Ladyship, the Chief Justice, Your Ladyship, the Deputy Chief Justice, my Lady, my Lords of the Supreme Court, my name is George Oraro, appear for the Attorney General.
Madam Chief Justice, Madam Deputy Chief Justice, Judges of the Supreme Court, my name is Jan Mohammed. I appear with Mrs. Wambugu for the 2nd petitioner when you had consolidated the cases yesterday.
Your Ladyship, the Chief Justice, members of the court, together with Tom Masharia, Njoki Mboshe, Steve Wandeto, John Njomo, and Paul Kiragu, I am Paul Nyamodi for the 3rd petitioner.
You may please, my Lady Chief Justice, Deputy Chief Justice, my Lady Justice Njoki Ndogu, and my Lords, I'm Otieno Willis. I do appear together with Mr. Nelson Osiemo, Ms. Caroline Kituku, Ms. Lea Chanimbanga, and Mr. Victor Oduol for the 4th petitioner.
May it please you, my Lady the Chief Justice, my Lady the Deputy Chief Justice, and the Justice of the Honorable Court. My name is Degwanjiro, together with Mr. Mituga and Mr. Morara. We appear for the 5th petitioner.
My Lady, my name is Ochiel Dudley for the International Commission of Jurists as Amicus Curiae, the 2nd amicus. I appear alongside Mr. Isaac Okero and Ms. Anne Ngige. Thank you.
May it please the court, my Lady the Chief Justice, the Deputy Chief Justice, and other judges of the Honorable Court. My name is Kibe Mongai, appearing for the 7th petitioner alongside Ms. Wairimo Kero.
Honorable Chief Justice, good morning. Members of the court, on behalf of the Law Society of Kenya's amicus, my name is Stephen Mwenesi. I am in this matter alongside the President of the Law Society, Mr. Eric Theuri, and we have a team of the Public Interest Litigation Committee guided by Counsel Maura Kabata and Dr. Musau and Dan Oino Kemo and others. I thank you for allowing us to participate.
Thank you very much. We have taken the appearances. We will straight away go to the petitioner's case.
It may please the court, I'm going to deal with the issue number 6 amongst the 9 issues that were crafted by the court for purposes of determination. And yes, and my learned friends, Mr. Firoz Norji, will deal with the issues captured in number 8 and 9. And my learned friend, Mr. Mwangi, will deal with the issue number 6. My learned friend, Mr. Philip Murgor, will deal with the issue number 1, 2, and part of 3. And my learned friend, Ms. Julie Soweto, will deal with the issues 3, 4, 5. I appear together with my colleagues for the first and second petitioners in the consolidated petition. The petition was filed on the 22nd of August this year, following the declaration of the results of the presidential elections that were held in the general elections on the 9th of August 2022. And those results were declared on the 15th of August 2022. Following that declaration, the petitioners, the first and second petitioners, were aggrieved with that announcement and consequently filed this petition. The petition is accompanied with a host of affidavits, and it may please the court, I'll refer to about 5 or 6 affidavits in my address. But as a matter of opening, I would want to deal with some constitutional issues as set out in the various articles of the Constitution. My lords and my ladies, after many years, the Kenyan people came about with the Constitution 2010. They enacted this, the Constitution 2010, and as opposed to the previous occasions, we had a constitution which was enacted by the people, in which they declared their sovereign authority. Therefore, anything done in the name of the Republic, in exercise of powers that spelled out in the Constitution, is based on donated or delegated authority as set out in Article 1 of the Constitution. Now, my lords and my ladies, it is important to put into consideration Article 2 on the supremacy of the Constitution, together with Article 3, which talks about the defense of the Constitution. As opposed to the previous periods when we had a constitution which was negotiated at the time of independence with the colonial authorities. This constitution established a republic in which the doctrine of separation of powers was embedded. And more particularly, my lords and my ladies, in this constitution, there were several constitution bodies and agencies that were created, which includes the first respondent, the Independent Electoral and Boundaries Commission. And in accordance with the dictates of the Constitution, the Independent Electoral and Boundaries Commission, just like any other body established under the Constitution, and for that matter, any person who resides in the Republic of Kenya is required not only to recognize the supremacy of the Constitution, but act in accordance of the Constitution and in defense of the Constitution. Under Article 249, all independent offices and independent commissions are required to respect the sovereignty of the people and also to promote constitutionalism. This is important because Article 249, as read with Article 88 of the Constitution, which vests powers on or to the Independent Electoral and Boundaries Commission, requires that those powers must be exercised in accordance with the Constitution. Now, my lords and my ladies, the story that emerges out of the events that occurred on the 9th of August this year, and subsequently following to the 15th of August, upon the declaration of the Constitution, of the elections, the presidential elections, goes contrary to the established provisions in the Constitution, and will enumerate those violations at the appropriate time. But in opening, I want to say this, my ladies and my lords, that this grievance that we place before you, the highest court in the land, is not just a conspiracy theory. It is not just any ordinary event. If you look at the evidence that is placed before you in totality, we invite your lordship to come to the conclusion that what happened on the 9th of August this year and the subsequent events that followed on the 15th of August mark a pattern of violations against the Constitution in order to undermine the authority of the sovereign will of the people, and in effect preside, that is the commission, preside over an election that in effect did not represent the will of the people of Kenya. Now, in saying this, my ladies and my lords, you will be taken through a host of evidence borne out in the affidavits that show clearly that the Electoral Commission, just like they did in 2017, did not preside over an election that was in accord with the requirements of the Constitution as laid out in Article 81 of the Constitution. Article 81 of the Constitution requires that an election held in the Republic of Kenya should abide by the general principles set out in that article, and more particularly, Article 81, Article 81E, that the elections must be free and fair, and Roman 4, the elections must be transparent, and Roman 5 of that article, that the election should be administered in an impartial, neutral, efficient, accurate, and accountable manner. My lords and my ladies, I want to emphasize the words accurate and accountable manner. And those provisions in Article 81 read together with Article 86, which requires that at every election, the Independent Electoral Commission shall ensure that whatever voting method that is used, the system is simple, accurate, again, the word accurate, verifiable, secure, accountable, and transparent. And more importantly, that the votes cast are counted, tabulated, and the results announced promptly, and that is at the polling stations. My lords, you would notice that as we appear before you today, we have something that has never happened in this country, that you have a commission that is divided right in the middle. That speaks to a dysfunctional constitutional body that is not capable, leave alone the transgressions that we are going to talk about. But we are talking about an electoral commission that is dysfunctional and cannot be able to preside over an election that would give it the stamp of legality and legitimacy as spelled out in the Constitution. And I think that is a matter that this court should not disregard. And we'll come to that a little later in our address. Indeed, the Tower of Babel has been brought down by the appearance of two factions within the commission before your lordships and my ladies. And this, in event, has created a situation where no Kenyan can believe that the pronouncement of the first, of the ninth, I think the second respondent, Mr. William Samoei Ruto, as president-elect, came out of circumstances as envisioned in the Constitution of the Republic of Kenya. And your lordships, we would invite you, and my learned friends are going to address you on this point as to what really happened within the commission. Now, coming to the subject matter that I'm going to address you on in the question of the issue number 7, that states that the declared president-elect, whether the declared president-elect attained 50% plus 1 vote of all the votes cast in accordance with Article 138, sub-Article 4 of the Constitution. We want to persuade you that the second respondent never attained that constitutional threshold. And going back to the Constitution on that particular article, Article 138, sub-Article 4, it was made part of the Constitution by the framers of the Constitution to give legitimacy to anybody elected as president to the effect that he had widespread support of the Kenyan people, and that is evidenced by the requirement that the president-elect must have at least 25% of the votes cast in each of the more than half of the counties. We are not dealing with that point. We're dealing with Article 4A, that it is a requirement, mandatory requirement, that the person elected as president must receive more than half of all the votes cast in the election. Now, talking about numbers in those two provisions speaks to the need for accuracy and accountability to give an election the legitimacy that the holder of that office would carry while exercising the powers of the President of the Republic of Kenya. And it's not an idle matter, because we went through an experience before the enactment and proclamation of this Constitution, that a person would be elected by way of a simple majority, and in circumstances in which you would find that the person elected as president did not garner more than half the votes which are cast in a presidential election. So this is an important matter. And the difficulty about this particular article is that it requires, at the end of an election before the declaration, that the Commission carries out some mathematics, some mathematical calculation and computation based on proper returns of the votes that were cast in the polling stations and transmitted, as it were, the results thereof to the National Tallying Center and verified accordingly in terms of the Article 38 and the Elections Act. Now, my lords and my ladies, my starting point would be the fact that in this election, it was declared that, and that is found in paragraph 7 of our petition, that the second respondent in the declared result garnered 7,176,141 votes, which according to the Electoral Commission represented 50.49% of the votes cast in the election. Now, this figure would be correct depending on the calculations that were carried out or computation done by the Electoral Commission based on the votes cast during the elections held on the 9th of August 2022. Now, the complaint on this in this particular regard is contained in paragraph 43 to paragraph 48 of the petition. And for purpose of clarity, with your permission, my lords and my ladies, I would want to read out those particular paragraphs of the petition so that I can properly put it in context. Paragraph 43 bars that the number of voters who turned out to vote in the general election held on the 9th of August 2022 remains indeterminate. The second respondent has been issuing contradictory figures on the voter turnout. On the 9th of August, 2022, on or about 1600 hours, 1 hour before the close of polls, the first respondent reported through various public news media outlets the voter turnout around the country was fairly low and was at an average of 52% of the registered number of voters. On 10th of August 2022, at or about 13 hours, in his first media briefing to the public following the close of polling, their second respondent announced that the total voter turnout in the general election as captured in the electronic voter identification kits, that is the KIM kits, was 65.4%, equivalent to 14,466,779 voters. Roman 3, the second respondent, however, indicated that he expected the above number to rise once the number of votes identified manually was taken into account. Contrary to the above declaration and reasonable legitimate expectation, the final voter turnout captured and declared in the final results of the presidential election in Form 3C is stated to be 213,137 votes, which is absurdly lower and not higher as anticipated. Notwithstanding a computation using addition of the valid votes in figures for the presidential elections, candidates in the aggregate results shows that the total number of valid votes is 14,213,027. Now, my ladies and my lords, the first point that is being made there, that if you look at the results as announced by the Electoral Commission and what is stated in Form C as the turnout of voters, and that is 14,213,137 votes. If you compute or add the number of votes cast for each candidate individually, that is the petitioner, the second respondent, and the two other candidates, that the figure that results is not the figure that was stated in Form 34C. The figure is 14,213,037. That is the first point. And this is important because as we proceed, we are going to demonstrate that the number of voters who took part in the elections and the number of votes cast in the election is indeterminate and is a moving target. It keeps on shifting. And I invite your lordships and my ladies to look at the results as set out in Form 34C and I equally invite the court to calculate the number of votes garnered by each of the presidential candidates. The figures do not agree at all. And therefore, the first point of reference, as it were, is that the computation of the figure 50 plus 1 was based on a wrong computation of the total votes cast, as it were, and as proclaimed by the chairman of the Independent Elections and Boundaries Commission. Now, this may be a mathematical paradox or even a conundrum. The numbers of voters who turn out to vote as declared by the Independent Electoral and Boundaries Commission should be the same as the number of voters that are declared emanating from the Kim's kits, because the source of the number of voters that have cast their votes can be garnered in two ways: by looking at the numbers as recorded in the Kim kits, or at the end of the election exercise by computing the number of votes cast in the election. And my ladies and my lords, you would find that in this election, again, if you take the number of votes, or rather of the voter turnout, which was 65.4%, 65.4%, as against the number of registered voters in Kenya, that, my lords and my ladies, would give you the figure of those who turned out to vote. Because the percentage of the registered voters who are declared as having turned out to vote must be the same as the number of voters actually whose votes are counted as valid votes cast, and of course minus what are characterized as rejected votes. So, my lords, if you look at that particular point, and we're going to go through this one, you will find that the chairman of the Electoral Commission, in his announcement of the final results as borne out in Form 34C, and his announcement of the turnout of voters, which is recorded as at 65.4%, is at variance. And therefore, his calculation of the results based on the percentages cannot be correct. In this exercise, I invite you in this exercise, I invite the court to look at the affidavit of one Edgar Ouko Otumba. That affidavit is swore two affidavits, a supplementary affidavit, and the first affidavit, which he filed on the 22nd of August. And my lords, in that affidavit, he makes a case, and Mr. Otumba is, has got a doctorate degree in applied statistics from Maseno University, and indeed he did assist this court in the previous petition in 2017. And he talks to the difficulties, that confronts us in terms of the various announcements that the chairman of the Electoral Commission made. And he states that on the 9th of August 2022, the respondent issued a communique, that is on paragraph 10 of his affidavit, on the day of the election, that the total voter turnout at 4 p.m. nationwide was at 56.17%. And that statement update is annexed to the affidavit sworn by the second petitioner, Madam Martha Karua. Then, at the close of the voting, the first respondent again issued a statement that the total number of voter turnout, based on the KIMS kit, was 65.4%, which culminates in a total of 14,466,779 votes. And that communique is borne out in the affidavit again of the second petitioner. In an affidavit that is sworn on behalf of the petitioners, first and second petitioners, Mr. Nyangasi Oduo, in his affidavit, he talks to the Form 34C, and I'd referred to this earlier, where the total number of vote cast is 14,213,000. Now, the same Mr. Edgar Otumba saw a supplementary affidavit on the, I think this affidavit was sworn on, just a minute, on the 20th of August, 2002. And I invite you, my ladies and your lordships, to look at this affidavit, because it analyzes several scenarios, including scenarios where the rejected votes are not computed, and scenarios where the declaration made by the chairman of the Electoral Commission as to the manual votes which were cast, which were recorded 86,889, and where those votes recorded as manual votes are computed together with the votes that were transmitted electronically. And then scenarios that would include the constituencies where the votes were declared later, including Ella's constituency. Now, the central point, and I want to make this point again, that the case that we are trying to make out is that if you look at the declaration made by the chairman as to the voter turnout, that will give you, as a percentage of the total number of registered voters, it will give you the number of voters that turned out to vote in the election, as opposed to another way of arriving at the same result, simply counting the number of voters that were recorded to have voted and cast their vote in the election. It is an equation that must agree in a mass submission. If the total number of voters that take part in the election do not agree with the votes that are counted as cast in accordance with Article 138(4), if they don't agree, then it means that the results of that election are not accurate, they're not transparent, and they're not accountable. And therefore, I'm inviting your ladyships and your lordship to go through this affidavit of Mr. Edgar Uko Otumba, because he lays out clearly there's several scenarios in which it is quite clear the second respondent, one William Samoei Ruto, could not have garnered 50% plus one of the vote cast in the election. And Since all that is in our submissions and is in the two affidavits that I referred to, I invite your ladyship and your lordships to go through, and you find that it is indeed very compelling, the analysis given out by Dr. Edgar Otumba. Now, your ladyship and my lords, I'd also invite you to look at the affidavit of one Celestine Anyango Opio, and in that affidavit, which enumerates several constituencies, including Chepalungu and many others, where in terms of the results as transmitted to the public portal, there was a systematic deduction of the votes cast for the first petitioner. And the same number of votes that were deducted from the petitioner were added to the votes of the second respondent. And the unique thing about this scheme is that the number of votes cast, the total number of votes cast, remained the same. The difference only was to the extent that the same number of votes that was deducted from the petitioner were given to the second respondent. And I leave that to your lordships to look through when you retire, because the Form 34As, in respect of those particular polling stations, attached to the affidavit of Celestine Anyango Opio. There is also the affidavit, two affidavits from Arnold Ochieng Oginga, and this is particularly important because it contains discrepancies of the results in several areas, and in voter turnout in Form 334C and the KIMS kit. And all this, my ladies and my lords, taken in totality, would affect the results of the elections. In paragraph 16, up to the end, he goes out analyzing areas where there were discrepancies, and you would notice, my lords and my ladies, that in totality, the discrepancies accounted for votes which are more than 140,000 votes. And in our submission, that has an impact on the result of the elections as declared. And I invite your lordships and my ladies to look at those particular analysis and annexures attached to the affidavit of Arnold Oginga. In the same way, in a further affidavit, Mr. Arnold Ochieng Oginga carries out an analysis in response to the responses to the petition by the respondents. And my lords, again, you would notice the number of votes that were being manipulated in order to secure a result that would favor the second respondent. And we have attached the relevant documentation, the forms showing the results, from 34As, 34Bs, those particular forms. And finally, the Form 34B, which is a collation of votes at the constituency tallying centers. Now, my lords, I would conclude by saying that unlike many elections, this particular election, there was deceit, there was manipulation, and all this was premeditated and made possible by the attack, if I may put it that way, on the IT structure and system of the Electoral Commission. The way that the Commission was able to deal with the forms when uploaded and downloaded, staged, transmitted, deleted, all this in totality, if you look at the case we put before you, my lords and my ladies, set out in the affidavits that I referred to, shows an election that was rigged in favor of the second respondent. And on that basis, my lords, we urge that you nullify the elections on the basis of the fact that the second respondent did not attain more than 50% plus one of the votes cast in the election. I thank you. I now invite Ms. Julie Soweto to deal with the second limb of our submissions.
Good morning, my ladies and my lords. I will deal with issue number 3, 4, and 5 as identified by the court, and that is whether there was a difference between Forms 34A uploaded on the IBC portal and the Forms 34A received at the National Tallying Center and Forms 34A issued to the agents at the polling stations. I will start with that issue. My ladies and my lords, the evidence that we supply for that issue is contained. First of all, the complaint is at paragraphs 81 to 91 of the petition, and the evidence is contained in the affidavits of Celestine Anyango, Arnold Ochieng Oginga, Benjamin Agina, and Benson Wesonga. My lady, in Celestine Anyango's affidavit, the complaint is made that in 41 forms from the polling stations that she looked at, the Forms 34A received by the petitioner's agents vis-a-vis the Forms 34A uploaded in the IBC portal and those brought to the tallying center are different. The sampled forms were from Bomet, Kiambu, and Kakamega counties. The evidence is at page 18 to 106 of the affidavit of Celestine Anyango. My ladies and my lords, this evidence should be considered together with the evidence in the affidavit of Benjamin Agena, sworn for the petitioner, paragraph 9. Which deals with the Forms 34A that the petitioner, the IEBC had stated it would procure, and the features in those forms that should have been used in the election. It is our contention that what the IEBC set out to procure is not what they procured in the first instance. Therefore, we cannot even match the forms that we have and that have been provided in the election to what they had set out to procure. We have stated in paragraph 110 of the petition, from paragraphs 108 to 110, that the IEBC procured 2 parallel sets of Forms 34A. Booklets 1 of 2 and 2 of 2. It was intended that only booklet 1 of 2 would be used at the polling station, while booklet 2 of 2 was to be placed in a tamper-proof envelope and not to be used at the polling station. The forms that have been transmitted, of the forms that were used to transmit the results in this election 2022, do not meet the standards or conform to either of the forms that the IBC said were going to be used, and this evidence is in the affidavit of Benjamin Agena. That is the first limb of the evidence that we submit through Celestine Anyango that shows the deliberate mischief in the use of the statutory forms that was set out in the election and which we now complain of. Going now to the evidence provided by Celestine Anyango in the 41 forms, what was observed is that the forms that the agents have and the forms in the portal are the same in all features. They have the same serial numbers. They are embossed using the same stamps. They're signed by the same agent, presiding and deputy presiding officers. However, the figures in the forms have been tampered with and are different with regards to the results for the first petitioner and the results of the first respondent, William Samoei Ruto. It is in the forms, or the sample of forms, the 41 sample of forms exhibited by Celestine Anyango, that votes have been reduced from the first petitioner and added to the first respondent, we have calculated the total number of votes reduced from the first petitioner and added to the first respondent, and they add up to 2,793 votes. My ladies and my lords, we contend that the figures are important because of the slim margin with which the first respondent won the election or was declared as the winner in the election. And the court, we asked the court to keep a note on that. My ladies and my lords, the difference between the result declared to overcome the 50% plus one threshold is 69,000 votes. 0.49%, which is the margin that the first respondent is said to have overcome the constitutional threshold, is the equivalent of 69,000 votes. And therefore, when we look at the results and the numbers that we will show have been tampered with, either reduced or removed from the first petitioner's votes, we will show that those discrepancies affect the outcome of the election or the result of the election. We have already shown that there is 2,793 votes removed from the first petitioner and added to the first respondent. There is also from Kakamega County the example where votes would be deducted from the first petitioner, but not added to any particular candidate. The mischief that is also borne out in our affidavits is that the intention was to ensure that the total number of voters remained exactly the same. So, for example, just a minute. I beg your pardon. At page 2 of the affidavit of Celestine Anyango's affidavit, at paragraph 4, my lady, just as an example, in Chepalungu, polling station 1 of 1, the first petitioners and the physical copy of the Form 34A that was given to the agent, the first petitioner had 61 votes. In the form that was uploaded, or that is appearing in the IBC portal, the first petitioner has 1 vote. In the Form 34A of the same polling station, the first respondent, William Ruto, had 109 votes. In the Form 34A in the IBC portal, William Ruto has 169 votes. The 60 votes that are reduced from the first petitioner are added to William Ruto. The total votes remain the same. The same continues in all the 41 polling stations that we have sampled and annexed to the affidavit. Similar to that issue is the evidence sworn by, in the affidavit sworn by Arnold Oginga at page 4 to 13, where he highlights discrepancies in the Forms 34A issued to the petitioner's agents and the ones uploaded by the first respondent, sorry, not the first, the IEBC, in the public portal. Arnold Oginga sampled polling stations, 25 polling stations in Baringo, 15 polling stations in Nairobi, and he finds the same results as Celestine Onyango, where a total of 1,570 votes are added to the votes of the first respondent, William Samoei Ruto, that are not borne out by the original Forms 34A issued to the agents. From the affidavits or the evidence of Celestine Onyango and Arnold Oginga, we conclude or find that the total number of votes deducted from the first petitioner and added to the first respondent is 4,463 votes. The second issue that I will deal with, my lady, is issue number 4, which is whether the postponement of the gubernatorial elections in Kakamega and Mombasa counties, parliamentary elections in Kitui Rural, Kachaliba, Rongai, and Pokot South constituencies, and the electoral wards in Nyaki West in North Imenti constituency and Kwanjenga in Embakasi South constituency resulted in voter suppression to the detriment of the petitioners in petition number E005 of 2022. The evidence that we rely upon for this is also in the affidavit of Celestine Onyango, Arnold Oginga, and the affidavit of Ezra Sunguti, who was an agent of the petitioners in petition number E005 of 2022. My ladies and my lords, the first complaint and the issue in this matter is that the elections, first of all, were cancelled only in the strongholds of the first petitioner. That is the consistent theme with all the counties or constituencies where the elections were cancelled. Therefore, as the election started, the first petitioner did not start equally with the first respondent. Ezra Sunguti deposed in his affidavit that polling stations did not open at the stations where he was manning as late as 1 p.m. due to failure of KIMS kits. One of the questions that we want to ask, because consistently the KIMS kits appear to have failed in the same region, in the strongholds of the first petitioner. It cannot be coincidental that only faulty KIMS kits were sent to the petitioner's strongholds. Ezra Sunguti also testifies in his affidavit that polling started at 2 p.m. and was not extended beyond 6 p.m., despite starting 6 hours later than when the polls were supposed to open. The effects of this: one, the time was not compensated. Two, by the time polling was starting, voters had left. The disabled, the elderly, and therefore the turnout in those polling stations was affected. This particular evidence has not been controverted by the respondents. On that ground, again, we submit that the cancellation of the vote in those particular areas suppressed the voter turnout, and this can be seen by looking at the voter turnout in those constituencies as compared to the voter turnout in neighboring counties or neighboring constituencies. We find that there is a vote differential of about 4% or 5% when you compare the turnout in the areas where the election was cancelled and areas where the election was not cancelled. My ladies and my lords, we also consider that the cancellation of the votes of the election in the strongholds of the first petitioner was deliberate because the reasons given by the IBC or the chairperson are not borne out by the statutory provisions for cancellation of the election. We have also sought to corroborate this evidence with the evidence provided by Irene Masset, who is a commissioner, who testifies at paragraph 26 of her affidavit that the reason why the votes or the election was cancelled in those areas was because the commission procured the wrong ballot papers. This is a mistake that Irene Masset, a commissioner.
May I, please, may I, with your very kind permission, Chief Justice draw the attention of the court that there may be on record more than one affidavit by Ms. Masit, to the extent that the affidavit that my learned colleague refers to is an affidavit filed by the petitioner. We have no objection. However, to the extent that that is an affidavit filed in the documents by Issa Mansour, whose documents our understanding of yesterday's ruling is, were struck out by the court alongside his notice of appearance, then there ought not to be a reference to that affidavit.
Yes, I think counsel clarify the affidavit she is referring to.
I will clarify to that. Sorry. My lady, I hope the time will be restored to me. My learned senior.
There is an error that was stated by my colleague, Professor Gidu Muigai. The ruling by this honorable court struck out the notice of appointment of Advocate Baisa, not anything else. That is what I heard with my own ears.
If I may please interrupt you yet
Counsel,
again.
please, without wasting a lot of time, we are capable of discerning what we meant with our own ruling. Let her identify the affidavit she is referring to, and when you are responding, then you deal with the issues that you are raising.
We appreciate that, my Lady Chief Justice. But I think if we proceed beyond this point without a common understanding by all the advocates as to what was the consequence of striking out the notice of appearance, then many on this side may make reference to those documents filed by Issa Mansour. To my own understanding of the law, once the notice of appointment was struck out, all consequential filings based on that were null and void and expunged from the record.
Proceed.
My ladies and my lords, that issue can be put to rest very simply. The affidavit that I refer to by Irene Masit is drawn and filed by MS Ouma J and Associates Advocates. I believe each of the commissioners had a right and did appoint their own advocates in response to the petition. And that is what I am referring to. So Malanid Senior is lost on that one. If I may proceed now. My lady, I do refer to the affidavit now of Irene Masit at paragraph 26 of her affidavit, where she depones that the chairperson and the commission secretary and the CEO failed to ensure that due diligence was done on procurement, proofreading, and printing of ballot papers, which is also a process that takes place prior to the general elections, and which in turn affected the elections in the areas that we complain the election was cancelled. She lists it, and for time, I will not refer to them. The averment is that the error on which the IBC relies upon, or the chairperson relies upon, that led to the cancellation of the result, was one of willful neglect. Irene Masit further testifies that there was no meeting as was required to be before the procurement was done, or verification to ensure that they proofread what they had procured. And she also testifies that in practice in 2017, this had been done before to ensure that this mistake does not occur. My ladies and my lords, to the extent that that admission is made by a commissioner, we submit that we are supported or find corroboration to our complaint that the cancellation of the vote in the areas in which we have complained about was deliberate and not accidental. The fifth issue that I deal with was whether there were unexplainable discrepancies between the votes cast for the presidential candidates and other elective positions. This evidence is found in the affidavits of Celestine Anyango, I beg your pardon. My ladies and my lords, the evidence is found in the affidavit of Celestine Anyango, where she shows at paragraph 8, 9, 10, and 11, where she has produced evidence showing that in 8 counties, there was a discrepancy between the votes cast for the president, votes cast for the governor, votes cast for the senator, and votes cast for the woman representative. The total number of the votes discrepancy is 33,208. And my lady, it is at this point that I reiterate again the slim margin between the result declared for the first respondent, which is 69,000 votes, to attain the 50% plus one threshold. In response to the discrepancy of the votes that we have highlighted, the IBC's witnesses, Sunkuli, Moses Ledama Sunkuli, I believe, states that those discrepancies are accounted for by prison votes. Because prisoners only vote for the presidential candidate. My ladies and my lord, if one looks at the total number of votes that have been provided as having been accounted to the prisoners, it is only 715 votes. You will find this at paragraph 53 of Sunkuli's affidavit. There is therefore no account for 32,493 votes. On that issue alone, we would like the court to consider, for instance, in Kirinyaga County, where the discrepancy between the presidential votes and the governor's votes was 23,550, which the only answer given by the respondents is that these were stray ballots. My ladies and my lords, a rough calculation of what is given as stray ballot for Kirinyaga County alone yields 33 stray ballots per polling station on average in Kirinyaga County, which we submit is not possible. This is also the kind of issue or discrepancy that, based on the rules, ought to have been brought to the attention of the National Tallying Center or the National Returning Officer. We rely also upon the authority cited in our submissions of William Kabogo, where the learned Justice Kimaru said a difference of over 5,000 votes between the parliamentary position and the presidential can only be as a result of fraud. My ladies and my lords, would also urge the court to note that at this election, the IBC had provided a clerk whose sole duty at the polling station was to ensure that voters placed their ballot papers in the right box. And therefore, the incidence of such a high number of stray or allegedly stray ballot papers cannot be explained and has not been explained. Finally, my ladies and my lords, as time is not on my side, we urge the court to look at the evidence of Arnold Ochieng Oginga on the discrepancies between the Forms 34A or the results declared in Forms 34A, Forms 34B, and Forms 34C. The design of the election was that this was to be a seamless transaction, and therefore the Forms 34A and the results therein ought to be the same as the Forms 34B and ought to be the same as the Forms 34C. In his affidavit, Arnold Ochieng Oginga finds that there is a discrepancy in the results to the extent of over 180,000 votes. That affects the result of the election or the outcome of the election. I will stop at this particular point and invite my senior, Mr. Paul Mwangi, to continue.
Madam Chief Justice, Madam Deputy Chief Justice, my lords, my ladies, I am to address myself to the sixth issue of the court, whether the IBC carried on the verification, tallying and declaration of results in accordance with Article 138(3)(c) and Article 138(10) of the Constitution. The thrust of my presentation is that the nature of management of elections in Kenya from even before the new constitution have been that decisions as to who has won the presidential election are collegiate. And that the collegiate nature of the decision as to who is the winner of a presidential election goes down to the description of what is a free and fair election under Article 81. And in Article 81E, the Constitution describes a free and fair election as an election, E3, conducted by an independent body, 4, transparent, and 5, administered in an impartial, neutral, efficient, accurate, and accountable manner. And it is my submission that this goes not to just what the Constitution says, but what Kenyans have practiced and what they have come to expect whenever bodies are making decisions. Possibly more than any other body, the judiciary has been able to show Kenya the nature of collegiate decision making. We have had live court sessions from the High Court to the Court of Appeal to the Supreme Court. Kenyans have seen often the presiding judge, in this case even the Chief Justice, consult even sometimes openly with other judges before the court arrives at a decision on even very small things. And we have even had situations when a decision becomes grave. We have seen judges retire to go so that they come back with a collegiate decision. So that is what Kenyans have come to expect, and that is also what Kenyans expect even from the Independent Electoral and Boundaries Commission. First, the nature, our commissions are made up of at least 3 members and at most 9. And if you look at the qualifications of all these members, they are all, whether it is the chairman or the members, largely have the same qualifications. They are all identified and recommended for appointment among the same criteria. They are all approved by the National Assembly. They are all appointed by the President. So there is no basis on which the chair of any commission can treat as subordinate members of that commission or treat them as if they have lesser qualifications or lesser competencies than him. They all enjoy the same security of tenure. They all enjoy the same security in their remuneration. And so they are all expected to execute very substantive mandates. My Lord, this question as to the mandates of commissioners came up in the case of Michael Kamau versus the Ethics and Anti-Corruption Commission, which is in our list of authorities, came up in the High Court and came up in the Court of Appeal. And the court, both courts were very categorical as to the fact that the constitutional mandate of a commission is borne by the commissioners. And in that case where a commission had attempted to reach a decision without commissioners, the court annulled that decision and said that that decision had to be made by commissioners. And in respect of the powers of a chairperson, again, the minor KI case all the way from the High Court to the Court of Appeal and to this court have made it clear that the chairperson is not the commission and that he has to act with the rest of the commission for him to deliver a proper constitutional decision. So that collegiate nature of the decision-making in a commission is captured very well in Article 138(3)(c) and in Section 39(1)(c) of the Elections Act, which make it very clear that it is for the commission to tally and verify the results. And in Article 138(10) is only where the chairman is asked to declare the result of that decision. And our submission is that the requirement to declare does not give the chairman any power to tally, to verify, or even to reach a decision as to what he is going to declare. That part of the Constitution was first captured in Section 41 of our previous Constitution, in subsection 11, which had a proviso that provided any decision of the commission shall require the concurrence of a majority of its members. And that is why I say the collegiate nature of decision-making at the Electoral Commission even precedes our new constitution. And at that time, there was an attempt, which I will submit is an attempt that has also been made this time by the chair of the Electoral Commission, to take away that collegiate nature of decision-making at the commission. And if you read the Kriegler report, which is also next to a list, it talks of an attempt at that time, or actually an actual creation at that time, of an office that was called the Supervisor of Elections. And the Supervisor of Elections was an executive office that was used to undermine the independence of the Electoral Commission of Kenya And as we moved to the first multi-party elections, one of the first insistence that Kenyans had was that the supervisor of elections must be removed and that decision-making regarding elections must be taken back to the ECK. But that was not even enough, because Kenya still felt then that Section 41 was still not clear enough. And in Act number 6 of 1992, which preceded the first multi-party elections, Kenyans insisted that the mandate of the commission be made clearer, and we now promulgated Section 42A into the old constitution. And Section 42A made it very clear that the Electoral Commission shall be responsible for directing, supervising presidential, national, and local government elections. So by the time we were coming to the new constitution, we had already taken a position that decisions regarding presidential elections have to be collegiate. When the new constitution itself was being promulgated, there were several options that the framers of the constitution could have. They could go back to making this the decision of an independent office, as Mr. Afula Chebukati has attempted to act. But instead, they created, for the first time, what they called independent offices, created the DPP, the Auditor General, and Controller of Budget as independent offices, but found it wise to retain the collegiate nature of decision-making as an act of the Commission. The question then we asked is, why is it necessary for there to be a collegiate nature in the decision-making regarding presidential elections? I say one is because it gives integrity to the decision. And the more important a decision is, the more it may require more people to make it. And we see that also in our court system, where decisions are made in the High Court by one judge, have to be made by 3 in the Court of Appeal, and have to be made by 5 at the Supreme Court. And this is even being seen in sports today, that in very important matches, they have even moved away from leaving critical decisions to one referee. And we have now gone to even video-assisted refereeing, so that more people can weigh in on a decision that is that important. The second thing is that the collegiate nature secures the independence of the commission itself, so that you don't have one person who can be in a position where they cannot resist maybe pressure. And therefore, so long as we know that there are 7 people making this decision, we are more confident about its independence. But thirdly, my lady, my lords, there is also the question of the legitimacy of the decision. And this comes from what this court said in 2017. And in paragraph 371, in the case of Raila Odinga versus IEBC, the court says that elections are the surest way through which the people express their sovereignty. Our constitution is founded upon the immutable principle in the sovereign will of the people. It says that, in fact, it is the people and they alone in whom all power resides, be it moral, political, or legal. And so they exercise such power either directly or through their representatives, whom they democratically elect in free, fair, transparent, and credible elections. Therefore, whether it be about numbers, whether it be about laws, whether it be about processes, an election at the end of the day must be a true reflection of the will of the people. And I view legitimacy in 2 ways. That first, it is very important for Kenyans to believe that the decision has been arrived at is legitimate. And the reason for that is because it is in one person. They have been asked to delegate their sovereign authority. So they believe that a decision has been reached that is legitimate is very important. And you see that in Article 131, the political legitimacy of that decision is covered in Article 131 of our Constitution. Because Article 131 gives our president 4 powers. He makes him the head of state and government in paragraph A. In paragraph C, it makes him the commander-in-chief. In paragraph D, it makes him the chairperson of the National Security Council. And then in paragraph E, it makes him the symbol of national unity. So of all the 4 things that our president must do, the A is the political legitimacy. And if decisions are arrived at as to who has won an election, and they do not carry with them the legitimacy that is required, then you have somebody who cannot exercise the duties, execute the duties under 131E as being the symbol of national unity. But there's a second reason. And the second reason is that also the person to whom you now declare as the president must himself believe in the legitimacy of the decision that has been made. And political scientists say that this political legitimacy is necessary because it finally determines how that person themselves will hand over that power. And political scientists say that power that is unjustly acquired will never be justly given. So if you want to have a legitimate transfer of power in a country into the future, you must ensure that that power is also known not just to the public, but to the person who acquires it as legitimately obtained. The question then comes to where we find ourselves today, where we have the chairman and a minority group saying they carry the day in this decision, and we have 4 commissioners. And the question this court has to ask is who did believe? And it's our position that Mr. Wafula Chebukati has disrespected the Constitution, has been unable to secure the legitimate result of an election that was conducted. And in terms of deciding who to believe, my lord, first and foremost, Mr. Wafula Chebukati has not had a complaint to make as to how these 4 commissioners worked ever since they entered the commission in September 2021. On the other hand, there are lists of complaints as to how he himself has conducted this election that start way back from 2017, that he bungled up the 2017 elections. We've captured in a petition that he has had 4 other commissioners resign on him previously. There's unilaterally printed ballots. He's unilaterally made decisions about use of registers. And in our both affidavits and petition, we have made a list of all the misconduct that he himself has executed. And the result of all that, you come to the conclusion that what the chairman has attempted to do is to install himself as a new age supervisor of election, totally emasculate the role of all other commissioners, and you now have a decision that is his, supported by a minority of the commission. And our argument is that that declaration is not a constitutional declaration. That declaration is unable to found the declaration that was supposed to be made under Article 131(8). And one of the most glaring things that comes also from that conduct is the issue of the 27 constituencies. And the 9th respondent knows the importance of that, because in paragraph 6 of his affidavit, he purports that those results were read. He purports that, in fact, that the disaffected commissioners announced those results. But the affidavit of Professor Goulier and the response of Chebukati themselves clearly say that those 27 constituencies were not verified and announced. And the reason for that, according to the 4 commissioners, is because he emasculated the role of the other commissioners and they never sat down as a commission. I will finish my presentation as to the unconstitutionality of that declaration with 2 examples. We have had previously a situation such as this in the Truth, Justice and Reconciliation Commission. I will ask the court to take judicial notice of what had transpired as the commissioners fought with their chairman regarding what was the report of the commission. And it was very clear that the report of the commission had to be what was decided by the commissioners. But I will also leave this presentation with something closer home. In the past couple of years, there has been a dispute between the executive arm of this country and the judiciary regarding who makes the decision as who becomes a judge. And it has been the position of the national executive that the power to appoint comes with it with some form of power to decide. And this judiciary has been very clear all the way from the High Court to this court that the power to appoint in no way includes a power to decide on who becomes a judge. I say that for the same reason, the power given to the chairman of IEBC to declare the result of an election in no way gives him any power to decide what that result will be. And if we cannot be shown how the commission as a commission reached a decision or reached the decision that was pronounced by its chair on the 15th of August, then I implore this court to use the same reasoning and tell the chairman in the same voice that it has told the national executive that your power to declare does not give you any power to decide on what you declare. That is all, my lords.
I haven't been in the court, so good morning, your ladyships and my lords. My humble responsibility today is to deal with technology, and that is covered in the issues that were framed by the Honorable Court as 1, 2, and partially issue number 3. I have been listening to the submissions of my learned colleagues, and I will try not to repeat any of them except where absolutely necessary. I start by referring to Article 86 of the Constitution. 86 provides for voting, and I particularly refer to 86A. The method, the voting method, must be simple, accurate, verifiable, secure, accountable, and transparent. I also read out to the court Section 44 of the Elections Act, which provides for the use of technology. How this has evolved is a matter that has been addressed by my learned friends and is well known to the court, particularly this court that has rendered decisions in the same regard. Section 44 of the Elections Act provides that the use of technology in an election should be an integrated electronic electoral system that enables biometric voter registration, electronic voter identification, and electronic transmission of results. Section 39 of the Elections Act provides for the determination of the declaration of presidential results. And in this regard, it provides at 1C, for the purposes of a presidential election, the Commission shall, A, electronically transmit and physically deliver the tabulated results of an election for the president from a polling station in the constituency tallying center and to the national tallying center. Regulation 14 of the Elections Technology Regulations 2017 provides as follows. Information security. The Commission shall put in place mechanisms to ensure data availability, accuracy, integrity, confidentiality, as set out in the first schedule. The Court is aware of Raila Odinga and another versus IBC 2017, where at paragraph 231, it provided and underscored the objective in the above laws. I will not belabor that. The technology envisaged by Section 44 of the Elections Act was intended to ensure an integrated and secure tallying and data transmission system which would allow computerized data entry tallying at constituencies, secure simultaneous transmission of individual polling stations, level data to the national tallying center, and the integration of the results handling system in a progressive election result announcement system. Two words that bear emphasis there is simultaneous and progressive election result system. Our submission in this regard is that the technology deployed by the IBC for the conduct of the 2022 general elections completely failed the standards of a secure, transparent electronic voting system, and thereby yielded what has aptly been described by my colleagues as an unverifiable, inaccurate, and therefore invalid results. Our further submission in this regard is that the technology was so inherently corrupted, manipulated, and tainted that the results declared by Mr. Chebukati, the third respondent, cannot be in an objective case said to be representative of the true will of the Kenyan people, as we and as I will demonstrate in my further submissions. On the evidence, the components, principles that ought to have been met in order to meet the constitutional standard of a secure and transparent system are as follows. Confidentiality is the first one I propose to deal with. This requires that the information within the process, and I'm not talking about the public portal, talking about the back end, should have been accessed by only those legitimately authorized. And those authorized, in order for them to be accountable, are persons whom the entire commission, in its, as defined by my colleague Paul Mwangi, the entire commission ought to have been fully aware of, gazetted where necessary, and it would certainly help if they were also Kenyan nationals. Integrity is the information used should be accurate, complete, protected by various and protected from malicious modification, which includes alteration or obstruction, either by authorized or unauthorized persons. Availability. The information required must be available as and when required by those authorized to use or access it in compliance with the constitutional requirements and the Elections Act. Non-repudiation, an audit trail must be maintained on activities related to the information. An audit trail in this regard is, should the court so require, should a party so require, it must be readily available in the appropriate manner. Authenticity, the information itself must be proved to be genuine, and the source must also be proved to be genuine. I submit on behalf of the petitioners that on the security aspect, there was lack of security. The first instance of that demonstrates this is the operation and use of the IBC and availability to, I repeat that again. The first is operation and use of IBC election materials and equipment to identified unauthorized persons. And I'm referring in this regard to the now infamous Venezuelan nationals. I will elaborate on that in a few seconds. The second is the penetration by way of hacking and illegally granted access of the IBC system by known and unknown persons. I distinguish between hacking and unauthorized grant of access. Hacking is where a person outside the system doesn't have the key, and I'm using the simple illustration, and so he accesses it through the roof, room through the roof or the back door, and he enters the system. The illegal grant of access is a situation where the codes, the credentials that are otherwise legitimate are granted to unknown persons. In the case of the now infamous Venezuelans, there is plenty of affidavit evidence on record, and I particularly refer to the affidavit of Martha Karua, the second petitioner, dated the 21st of August 2022, which contains or encloses the statements by the DCI, and of course the rebuttal by Chebukati on behalf of the IBC. Your Ladyship, my Lords, I also refer to the affidavit of Juliana Cherera. I also refer to Annexure JC3, the National Police Service press statement dated 22nd of July 2022. Annexure JC4, press statement by ABC Chairman dated 21st July 2022, stating that the three key personnel responsible for the deployment and management of elections infrastructure and that the three Venezuelans were employees of Smartmatic International BV. I also refer to the Annexure JC5, press release by the Directorate of Criminal Investigations dated 23rd of July 2022, detailing the crucial election materials irregularly and illegally found in the possession of three Venezuelan nationals. Their names: Jose Gregorio Camargo Castellanos, that is one name, one person; Joel Gustavo Rodriguez Garcia; Salvador Javier Sosa Suarez. Those were the persons named in the detailed Directorate of Criminal Investigations report. My Lords and Your Ladyships, I would like to emphasize that the Directorate of Criminal Investigations is the national institution charged with the responsibility of investigating crime. Crime in relation to the Penal Code, the Elections Act, all crime. And that evidence the statement by the DCI regarding the Venezuelans is not a matter that can be taken lightly, and wished away by the chairman of the IEBC. I will deal then with the issue of the penetration or the compromise of the IEBC system. And I ask the court to look at the affidavit evidence of John Mark Gidongo, 2 affidavits or 3 affidavits, Benson Wesonga, an IT forensics expert, George Njoroge, IT forensics expert, and the forensic analysis of the DCI of a laptop confiscated from one Kip Ngosos at the National Tallying Center. I also asked the court to look at the affidavit of Justus Nyangaya, who is one of the commissioners. Which responded? Sixth respondent. Thank you. I will summarize the affidavits. The evidence of John Mark Gidongo, he has sworn 2 affidavits, one on the 21st of August 2022 and the other on the 28th of August 2022. In his affidavit, at paragraphs 2, 3, 8, 9, and 10, he talks about the illegal access into the system and manipulation of the presidential results, how it was orchestrated and implemented. At page 4, paragraph 12, he produces evidence of a video recording. Paragraph 8, page 8, paragraph 16, he witnesses how he saw this young person illegally and very easily access the IBC system, where he was able to see information including that of his name and other accredited observers at the IBC National Tallying Center, and pages 13 and 18 of certain screen grabs. In the affidavit dated 28th August 2022, page 2, paragraph 4, John Gidongo clarifies what was given to him in the first affidavit, but more importantly, at page 2, paragraph 6, he produces the actual logs that were used to show access to the system. I wish to make a short submission regarding the evidence of John Gidongo and the transcribed interview he had with this young person. And I'm discussing this in the context of the probative value of that conversation he had with this young witness. It came out that somewhere, somehow, in the current suburb, there was a group of about 50 people who had access to the ICT systems of IBC, whereby they were intercepting results before they were uploaded on the public portal. When that was put out and the responses first came, that suggestion was rubbished. But in further evidence, I will demonstrate to the court that it now turns out that that is probably and most likely what happened and what created this entire mess that is called the election results of the 2020-22 presidential election. In the case of George Njoroge, whose affidavit is on record, whose CV is on record, a computer forensic expert with wide-ranging experience in investigating all manner of crimes, including those involving terrorism, through investigating the IT aspect. In his affidavit dated 28th August 2022, he has attached his detailed audit and analysis report of IBC results transmission system and operating system log files. And I emphasize that amongst those he analyzed are the logs annexed to the affidavit of Justus Nyangaya, who is the 6th respondent, and who was the commissioner of IBC in charge of ICT. I emphasize this because it tells us the logs, that information from the logs comes from within the IBC, the first respondent. And therefore, it must be taken as correct. Indeed, in one of the witness statements we have, or affidavits we have from one Mr. Nyaga, in various affidavits, together with Mr. Uma, they are defensive, together with Mr. Chebukati. They reject the suggestions, but when the logs from Mr. Nyangaya are finally analyzed, they are suddenly, in particular Mr. Nyaga, forthcoming. In the case of Mr. Nyaga, and I will refer to his affidavit, his first reaction is to suggest that they have been illegally obtained and a crime has been committed and somebody should be prosecuted. In fact, the DCI should take action. That is an admission that at all times something vital to the verification of the process was being withheld, not only from this court, from the entire Republic of Kenya. George Njoroge has provided a detailed audit and analysis report, and he, at page 1, paragraph 5, confirms that he analyzed the log files. Page 11 shows the image application for each of the 6 IEBC servers that had information. And of course, at this point, I'm hopeful that in the scrutiny, the same 6 IBC servers shall be availed by the IBC as quickly as possible. Page 3, which is the part of the report that confirms several authorized individuals were illegally authenticated to gain access into the core of the live system. Several authorized individuals were illegally authenticated. We'll go and demonstrate that, because authorized could mean you're within IBC, but illegally authenticated, you have gone well above your pay grade. Page 14, 40, page 14 of the report, 14, 40, and 41, confirms that there was evidence of remote access to the system on the 13th of August 2022. 13th being 3 days after the voting. Remote access means somebody outside the walls, virtual walls of IBC. In other words, somebody somewhere sitting out of the system has the key and can log in. Transmissions of numerous forms from a single host server whose IP address was given or is given as 172 full stop 21 full stop 5 full stop 4. Contrary to the expectations that the forms would come from various KIMS kits directly to the NTS public portal. I illustrate this, or I explain this by stating that Mr. Chebukati, chairman, went on record as saying, this is a very simple system. From the constituency level, it shall come to the National Tallying Center, onto the portal that is public. He has no intervention whatsoever. He can't stop it. It comes. To the extent that I remember one conversation in one press statement, he was asking the press, why are you so slow? You know, I'm faster than you. But that is how it was supposed to happen. But the evidence will show that we have provided that there was an illegal, malicious, and unauthorized existence of commission staff who are not officially gazetted and mandated to be part of the electoral process, but who had access. Page 15, and one of them I should state now was his personal assistant, whose name I shall provide shortly. Page 15 shows that there was evidence of, this is important, there was evidence of downloading and conversion of the forms from the system and thereafter uploading them with new information. Your Ladyship, my Lords, I explain this by saying a Form 34A has been uploaded from the constituency level by the returning officer. Before it hits the front end of the public portal, meaning the side that we will all have access to, it is downloaded, it is changed, converted into a system known as CSV, which is comma separated values, that's what it means, which is an editable format from the original PDF format. PDF, we all use that abbreviation without getting what the meaning. It means portable document format. The PDF cannot be edited, whilst the CSV provides the opportunity, the facility for editing. So if one were minded, that is the point, and we submit that is what happened when the numbers are changed within the Form 34As. Otherwise, there would have been no need for downloading the system, the documents, and uploading them after after a bit of time, sometimes hours, sometimes a few seconds. Page 16 and 21 shows a continuous generation and regeneration of 35C, yet 35C was 34C, yet 34C was supposed to be generated only once at the very end of all the information from 34B coming in, and of course 34A. Page 17, this is an important component of our submission. There was overwhelming evidence of back-tallying of presidential results. This means that a Form 34C was being generated with a result, a desired result, and thereafter what seems to happen is a process of going backwards to change Form 34B and 34A to give the result that was desired. This happens continuously, and it is illustrated very well in the evidence of Mr. Njoroge. What is obvious, but bears repeating, is that the process, the system was only supposed to work forward going, not by way of back tallying, meaning 34A, the aggregate of the 34A was to create the 34B, and the 34B aggregate would create 34C. Once 34A, as many as there are polling stations, etc., going forward. But what you see from the report of Mr. Njoroge is after the voting, until the results are announced, far too much activity, all starting with the generation of a 34C. The analyst is not able to know exactly what is going on, but it can be surmised from the abbreviated logs that show you're seeking to generate a document, and in computer parlance, that means you're seeking to edit something, you're seeking to change something. My hypothesis from where I stand is, and I'll state at the very end, clearly a result for the first respondent, that is Mr. Ruto, was being arrived at well before the tally was in. And each time work was being done to try and fit A and B into that result. And through the confusion, because people who engage in such exercises make mistakes, at the very end, the result is forced on Kenyans through a defective 34C, where the commissioners cannot agree, and Mr. Chebukati walks and says, it doesn't matter, third respondent, it is my result, and you can tell what you want to the birds at Serena. So, the process ought to have been, ideally, 46,232 Form 34As ought to have been generated into 291 34Bs, and in turn have generated one, I repeat, one 34C. However, you will find, your ladyships and my lords, that an analysis of the logs shows several regeneration of 34Cs, which in turn lead to what I have just described. But at all times, you see a downloading of 34As in the CSV format, which is the editable format. Page 20, 21 and 22 show that as of 21st of August 2022, the hours are 15:48, 33 seconds. A Form 34C had already been generated. I repeat that. As of 12th August 2022, 15:48 and 43 seconds, a Form 34C had already been generated. The results were hardly in, according to IBC. What was the business of anyone within that system generating a 34C? We were 2 days away from the final announcement. Page 23 also shows that similar transactions as the one on 12th August 2022 was done on the 14th of August 2022 at 3:57 and 1 second. Page 23 shows that Form 34C was received in a PDF format at 3:57:01. Thereafter, instructions issued to the system to receive data to create 34C. And thereafter, an action of starting document Form C generation is commenced and finally was successful. Page 25 shows the above action was repeated on the same day at 4:1:33, and it goes on and on. I don't wish to take up too much time. It is all clear. Page 65 shows on the 14th of August 2022 at 15:34:12, there is an ambiguous and intentional modification overriding the whole process to finally generate Form C document. Data from Form 34B is then entered only once into the Form C, when there should be several entries to the Form C on different dates. Page 15 shows that there's a presence of illicit data in the presidential tallying system. Illicit means unexpected. There was plenty of Form 35Bs, which should not have been in the same portal. I move on. This you will find is repeated on and on. Page 43, 76, and 77. We see IBC personnel who were not gazetted for the purposes of the restricted and accountable access to the system were granted access to the system. In particular, the personal assistant of the chairman of the third respondent, Mr. Dixon Kwanusu, is granted access. As a rejoinder, we have seen a belated authority to have such access, which is well after the election. But he is not gazetted, so he is invisible. This court, if we hadn't brought the logs, it would never have been known that Mr. Dixon Kwanusu had wide powers in this system. So, whilst in this dispute, we may not see the fingerprints of the third respondent in the ICT system, we see his palm, his much larger presence through the actions of his PA. Indeed, you will find, when you study the system, that Dixon Kwanusu performed a purported verification process of 34As 1,743 times. The same scrutiny revealed that at page 28, one Abdi Dahir, who was not gazetted and who is belatedly granted access and privileges to the system, purportedly verified 659 Form 34As. Yeah. So, I ask the court to look at the affidavits of Ben Wasonga. He is also another computer forensic expert. His evidence is substantially the same as George Njoroge. I will ask the court to note that the tender documents did provide that whoever was to provide the system was to be able to provide a KIMS kit that would provide compressed color photograph images using a compression technique that is in compliance with JPEG. However, the court will find that all finally displayed Form 34As were in black and white. I will shortly mention that it becomes evident that there is interception of data. It's called a man-in-the-middle or machine-in-the-middle attack, and it gives probability and great it supports fully the evidence of George Njoroge and John Githongo that in fact the system had unauthorized persons. I would go quickly to the evidence of again Benson, who in his affidavit shows that there was not only one foreigner involved, there was several of them, and the ones I had mentioned earlier, and throughout the process of counting, several of them were involved as super administrators. Super administrators is the power to even create and join servers to the system, change, alter documents, delete documents. This is at page 2 of paragraph 9 of the affidavit sworn on 28th August 2022, where the super administrator, in this case, the one J.C.A. Margo, who occasionally uses a different name, is able to create user accounts, install applications, change user roles, assign resources, read documents, write documents, modify or edit documents, and delete documents. I honorably suggest that it shows that this election was controlled from everywhere except IEBC. And I have read the affidavit of Mr. Chebukati. He suggests that the Venezuelans felt harassed after their arrest and left the country, but I respectfully submit that they remained fully connected to the IEBC servers. I have said page 3, paragraph 8 shows the unauthorized users accessing the system, a total of 6 of them being, I found the page, is C. Silva, Josio, Vito, JCA, Margo, Ogudino, and J. Lugo. I conclude by saying, what is the response of all these very serious allegations? I say that we get it from the affidavits of the 4 commissioners who have differed with the chairman. They have stated categorically that that whole system was created by was controlled by one person, the third respondent. They were kept in the dark. Mr. Nyangaya, who was in charge of ICT, was also shocked that foreigners were controlling the system and had access during and after the election. And I point out that Mr. Chebukati did not offer this to the court in his replying affidavit, and it only was offered through his subordinates when the evidence was availed. I conclude conclude by submitting that what we have before the court is clearly a corrupted, and I'm not talking about a person, I'm talking about the verb, a corrupted and compromised RTS system which does not meet the demands of the Constitution and the Act. And it is only a matter, it is a matter that will be determined after scrutiny whether something can be retrieved from the system, which includes, and we focus on the results that were first uploaded onto the KIMS kits. Perhaps that's where we will find some truth. But whatever got to Bomas of Kenya was totally corrupted, I submit, by corrupt IEBC officials. I lastly point out that you will find in the affidavit of Mr. Benson Wasonga, Smartmatic, by some strange coincidence, is reportedly mired in several controversies in the management of elections technology around the world, including Venezuela and the Philippines. So perhaps that makes them unqualified to most of us, but makes them eminently qualified for the fraudulent objectives of the first and second respondents. Thank you.
No, you didn't. We are well with My Lady Chief Justice, my ladies, my lords of the court, I address the court on issues 8 and 9, the magnitude of the matters which you've been listening to and which are set out in all our documents, and I will turn later to the prayers. This morning, in the last 3 of the submissions from my colleagues, the question of what Mr. Chebukati was doing when Article 183 began to operate, 138 began to operate once the 34As moved from the polling stations to the constituency levels to become 34B, and then from there to the National Tallying Center. And Article 138.3 is Article 138 is entitled, the marginal note, Procedure at Presidential Election. And sub-article 3 is, in a presidential election, paragraph C, after counting the votes in the polling stations, the Independent Electoral and Boundaries Commission shall tally and verify the count and declare the result. 138.3c. And so there are 3 steps to be taken after leaving the polling stations. They shall be tallied and verified and the result declared. And the party that is tasked with the duty of doing these 3 things is under the Constitution, the Independent Electoral and Boundaries Commission. But as you have heard, as you have read all the documents, we saw only Mr. Chebukati doing these duties and not doing these duties as part of the commission, but by himself, together with his clerks, together with his team members, to which I will come in a moment, but not in their capacity as having any decision-making powers over the steps he was taking as the person doing tallying and verifying. Why was there not the Independent Electoral and Boundaries Commission not taking these steps by itself or through itself? And the answer to that is given by Mr. Chebukati himself, and it is in his replying affidavit, sworn on the 26th day of August 2022. And this is what he is setting out in paragraph 108. Sorry, 103. Thank you. On page 10, members of the court, my apologies, to paragraph 37. And this is what Mr. Chebukati says, that the commission, from Gazette Notice number 9540, number 155, dated 8th of August 2022, a day before the election, outlined the result pathway from the polling station to the national tallying as follows. And then he quotes the Gazette Notice, subtitle, "The Presidential Returning Officer," into brackets, Commission Chairman, Roman 1, receives Form 34As and 34B. Article 138 is reading that the form should be received by the IBC. Roman 2 from the Gazette Notice, the Presidential Returning Officer, Commission Chairperson, verifies. And later on, again, he says, declares. Where does he get this authority from? Is from the Gazette Notice. And so that Gazette Notice is set out in his affidavit. And the Gazette Notice is reading on page 36. This Gazette Notice is in the X made, and it sets out the result paths at the National Tallying Center, which we have seen. And so we search for the authority to move away from
Article 138? How did it get from IBC to Mr. Chebukati? In exercise of the powers confirmed by Articles 88, 44 of the Constitution, Section 4 of the IBC Act, Sections 38, 39 of the Elections Act, and Regulations 87(1)(b) of the Elections General Regulations 2012. This shift has come through these General Regulations 2012, which were amended at a different time, and brings a different receiving party. And that receiving party is the returning officer, into brackets, commission chairman, and the 87 itself, the regulation, is an amendment and is referred to by Mr. Chebukati. We submit that Regulation 87 and this pathway that he has put down is a repeat of Article 138(3)(c), but with one significant alteration. Instead of the IBC receiving the votes, instead of the IBC verifying the votes and declaring the tally and the verification, he has put his own name, the chairman. Simple submission we have that this is subsidiary legislation. The pathway which he was relying on in the Gazette notice is void totally. The subsidiary legislation from which the Gazette notice is derived is void, as being in total conflict with not only its principal legislation, but with the Constitution itself. This is what takes the tallying and verification process away from the IBC and took it into what was happening from the 9th of August right up to the 15th of August. And this was breaking every single national value set out in Article 10. And because this too was a checkpoint, it is widely believed, and the chairman is the first to fan this, that there is only one key checkpoint in the process of counting, and that is 34A at the polling station, close of polling, a photograph, the Keams skit, and that's the check. We have to understand that there isn't only one check. There is a second key check. From the 34As to the 34Bs, there is generated 34C. And 34C is so key that it needs a second check. And who is there to do that checking? No longer the agents at the polling stations. In their place, the Constitution sets the IBC, the 7 commissioners. And the 7 commissioners are checking the movement of the thousands of 34As into 292 or 290 of the 34 Bs. And the people watching them are the 7 commissioners who are representing the people of Kenya overlooking the process. And by shutting them out, as has been set out by numerous of the affidavits and the television itself, that those 6 were kept away from the process of verification, so that the participation of the people of Kenya over the process of establishing the will of the people was closed down. But there is even a more dangerous thing going on here, and it is this. By this amendment, there was a concentration of the entire process, both of the verification as well as the decision-making as a consequence of that tallying and verification, a concentration into only one individual. And it gave him the power, that Gazette notice, that subsidiary legislation, in violation of the Constitution itself, to take these decisions, and vested in him an asset, a power to find a result all by himself, with no check. And if such a person were an auctioneer, then he had got into his hands, if you want to be a successful auctioneer, you must have something to auction. And this, the supreme prize in our politics, in our national life, in our institutions, had come into the hands of one person. This is a danger so great that it has been the push from the beginning of this election campaign, before the election. Keep your eyes on 34A at the polling station. Anybody who questions anything after that is an agitator, a person who is out to commit violence, is a person seeking this and that and the other. These are all decoys, taking away the key information that one man is doing this, and this petition is the most important petition that we have had. It is from this bench. There are 3 counsel here who filed and were present and argued the first presidential election petition against an incumbent 25 years ago, in 1992, now 30 years ago. And we have had to move step by step, pushing from very crude checking against very crude stuffing of ballot boxes to this day, when our ballot boxes are being stuffed with a highly sophisticated other writing form. And this is not about 2 people, it's not about 1 person, it's not about political ambition. This is what happens when this chairman is left to do what he has carefully managed to do. And it is therefore our first prayer that this court, the Supreme Court, holds and declares that the Gazette notice and the 87 subsidiary legislation of the general regulations is null and void for being contrary to its principal legislation and constitution. This is why there are people going to people's houses at 3 a.m. and 4 a.m. But is it something so unbelievable? No, this method, how is it that every 5 years, under the chairmanship of this particular officer, we have a crisis? Let me show you another step taken by Mr. Chebukati in this election. On the 8th of August, Mr. Chebukati announced that the gubernatorial elections for the next day in Mombasa and in Kakamega were postponed. And he puts it out in a Gazette notice. Once again, we have queried whether that was a decision of the commission or of himself. And we asked the reasons. And he has set out the reasons in that same affidavit at page 25. And at page 25, he sets out why he had to do it. Sorry. And this is what he says. Paragraph 103 of that affidavit on page 25, that despite spirited efforts by him and his whole teams, whatever they are, to have the printer replace the ballot papers urgently, it was not possible, he says, to complete all logistics in time for the elections. In the circumstances, the commission was constrained, now he is seeking their umbrella, was constrained to postpone the gubernatorial elections in Kakamega and Mombasa, and then he gives the authority. Pursuant to Section 55B of the Elections Act and Regulation 64 of the Elections General Regulations, which allows the Commission to postpone an election in a constituency, county, or ward, quote, I've been quoting, quote, where it is impossible for an election to proceed, full stop. Then he says that the postponement was for a limited. So he has set out that it was postponed under these two sections and regulations where it is impossible for an election to proceed. So we look up Section 55B of the Elections Act. Here is 55B of the Elections Act. Postponement of elections by the Commission. Section 1. The Commission may, where a date has been appointed for holding an election, postpone the election in a constituency, county, or ward for such period as it may consider necessary, where A, there is reason to believe that a serious breach of peace is likely to occur if an election is held on that date. But Mr. Chebukati says that's not the reason. B, it is impossible to conduct the elections as a result of a natural disaster or other emergencies. He hasn't said it was because of the natural disaster or other emergencies. He doesn't say they were there. C, that there has been occurrence of an electoral malpractice of such a nature and gravity as to make it impossible for an election to proceed. A, B, C. None of these were applicable, but even if they were invoked, none of them were present in fact. But see what Mr. Chebukati had done. He had lied. He said that in Section 55B, it is provided that they may postpone if it is impossible to conduct the elections, full stop. And when we look at Regulation 67, it's identical with the same conditions. Once again, he is lying. And there is not the slightest concern, for the values of Article 10 and the whole Constitution. This is two things here to watch, members of the court. Number one, that this is a person who is saying these things with impunity. This is a person who sets out the wrongdoing that he is practicing with mens rea. This is not a mistake. This is a very calculated, very calculated subversion of forethought. He plans this, does it on the last day, doesn't explain what those conditions are which make it impossible, and delays it. And then it does not matter to him that at least 2-3 million people in Mombasa County and Kakamega County have been deprived of their right to vote. That it is important and reversing that a presidential election has to be held on the days when the general election is held. This is how the mess that has brought 100, a full Supreme Court, here. Because this man, when you ask him these things, justifies it, knows that it is wrong, and puts it in an affidavit. And then says to us, you explain it. So, it is important not that we cannot rely on a single thing. This is a practiced artist of the destruction of our institutions, because that is what happens. He did it in 2017. He was caught. When the court ordered him to disclose more things, he disobeyed the order, never did it, and took the benefit of the continued change of circumstances, a new election, etc. And now, back again, he is here. Same person, same sort of tricks. This was in 2012 and 2013, this amendment. This man has been practicing this for 2 election cycles. And he comes here, read this affidavit. Every 2 sentences he says, I'm conscious of the importance of my work as a state organ or a state officer. I'm a practicing advocate, and my professional integrity would never allow me to do these things. I told the NSIS, I am standing up for what is right. I told the 4 commissioners, never, I don't do things like that. When people are running, the person who calls out louder, thief, thief, thief. So that this is what has been going on, and it is destroying our institutions. This case is about the democratic institutions of Kenya. And it is about how we protect those institutions and how we stop people who are attacking those institutions. We cannot do it on the streets. We do it through the institutions. We were doing it through the bar. Now the burden has come to the judiciary because of the new constitution. And we pray that that burden will be borne constantly, persistently, with courage, because when such burdens are not borne, all of us fall down, including courts. And is that something that should be, is that something that has to be spoken to, I mean spoken for, by a party who is seeking justice? And the answer, fortunately, is no. The Constitution itself gives the answer. And that is set out in Article 3(2), which says that it is the duty, every person has an obligation to respect, uphold, and defend this Constitution. Defend? Armies coming from abroad don't care about our Constitution. We're not defending this Constitution against armed incursion from anywhere. That defense is from enemies within who use this type of thing. It is not unusual. The subsidiary legislation emanates, as we all know, from the institution itself. And a letter goes to the Attorney General saying, I would like to amend this. This is what I want. The Attorney General says, give us a draft. The draft comes, sent to the draftsman, legal draftsman. First draft goes to various ministries, Attorney Generals, other departments, public, to the Interior Ministry, So this has been done very calculatedly. Very few of us are going to read this to see it, but no one even saw it in 2017. So we have work ahead of us. And so may I turn then to the second issue that I'm coming on to submit to your ladyships and lordships, and that is sure. Thank you. Sorry, Mary. So the prayers are there. We are asking for prayers in the petition, and we respectfully request that the court looks at them and deliberates on them. But the court also has powers from other places. For example, in the Elections Act itself, under Section 80, subsection 4, the court has power. The court has power to, if there is evidence that you find, you may issue directions that the certificate is to be made out in the name of the person who has secured more votes. The second prayer we do make outside this is this, that we cannot have, whatever the outcome of this petition, we cannot have the self-discredited person who is giving false affidavits and doing all these things to be the chairperson of the IEBC or anything at all. And so we are also saying that there are two prayers in relation to this. The Article 3 of our Constitution says this. Article 3, sub-article 2. And this is at the heart, I pray, of the judgment that this Honorable Court gives. 2, any attempt to establish a government otherwise than in compliance with this Constitution is unlawful. Any attempt to establish a government otherwise than in compliance with this Constitution is unlawful. And so, in what is a 34C? A 34C is what leads to 34B, which leads to the declaration of a precedent, which is the formation of a new government. That is what was going on the 15th of August there. An attempt, and even here, right now in this court, there are people who have filed things in contravention of the saying that what is in contravention of the Constitution is correct. And right here in this, there is an attempt to establish a government otherwise than in compliance with this Constitution. It's unlawful. So, if this Honorable Court finds that Mr. Chebukati is responsible for and has committed actions and decisions which are an attempt to establish a government otherwise than in compliance with this Constitution, we pray that you make a holding that he has done such an attempt, which is a mechanism within the Constitution itself and within this election petition's four corners, and a second and another declaration that this person, pursuant to Article 33, sub-article 2, is no longer fit to hold public office. We go further. Is it possible that we can stop it by stopping Mr. Chebukati alone and we submit? No. It doesn't matter whether Mr. Chebukati will find another Mr. Chebukati next time. We have to stop those people who do not take those steps, but who take the benefit of those steps. And those people who take the benefit of the steps which the Constitution itself says is unlawful cannot take public office on the basis of a false 34C, 34D, of a declaration made by a person who knows he's made it falsely, so that we also pray that those who seek to benefit from the wrongdoing of Mr. Chebukati are themselves caught by Article 3, Sub-Article 2, and you have the powers to make the same orders, that they too are making an attempt to establish a government in Kenya otherwise than in compliance with this constitution. And we pray that this court moves our country forward with those two steps of orders in relation to all parties benefiting and all parties carrying out this mass attack upon Kenyan democracy. Thank you.
I pray to the court to allow me to say a few things in conclusion. And I'm honored to come after my senior, Mr. Firoz Norji, senior counsel. I cannot forget to put it on record that in 1993 I filed a similar petition challenging the election of the then president, and my lawyer was Mr. Firoz Norji and Mr. Paul Mwangi, and I'm forever grateful. And so was Mr. Paul Mwite, senior counsel. Many times I was locked up, he was always available to appear for me, and like many other counsels who are here. I want to urge the court that what has been put on record, and particularly the evidence that has come through the submissions of my learned friend, Mr. Morgor, it's so important in terms of making a decision as to what to do with the elections that were held on the 9th of August this year. And Mr. Morgor has put evidence before you which has not been controverted. For example, there is evidence of interference, if not invasion, of the technology infrastructure of IEBC, and the evidence of Mr. George Njoroge, which was covered by Mr. Morgor. I want the court, with respect, to look at what the IEBC has said in return or in response to those very, very serious allegations through Mr. Martin Wachira Nyaga, again was referred to by Mr. Morgor. He does not deny the disclosure of the 6 logs from the 6 servers. In his affidavit, he actually acknowledges the logs which speak to access to the servers without authorization. And he puts the question the other way around. Instead of this matter going into inquiry by the Electoral Commission, he questions the authority of Mr. Njoroge in accessing, in obtaining those logs. And he says the same things about the logs that have been put forward by Mr. Justice Nyang'aya. The authenticity and integrity of those logs have not been rebutted. We are treated to an explanation in the affidavit of Mr. Wachira, in particular about the generation of Form 34C. And those rebuttals do not answer the question as to why there are these unauthorized access to the servers of the IBC and obtaining those particular logs. There is also in the bundle in the evidence through the affidavit of Mr. Nyangasi of 2 Form 34Cs, one generated on the day the results of the elections were declared on the 15th of August, and the one that was generated on the 15th of August 2022 is based on the results obtained at the county level. The next day, again, another Form C was generated. All that is in the bundle of Mr. Nyangasi. Another Form 34C. That one was computed on the basis of the results that were obtained from the polling stations. So we got 2 Form 34Cs. There is no explanation given as to why there was those 2 forms. So, Your Lordships, we pray that the orders that we prayed for are justified. But probably in future, there may need to be a thorough inquiry as to what happened. Not just looking at the question of whether Mr. Ruto was validly elected, but looking at the criminality that characterized this entire enterprise. And that is when the Kenyan people will know the truth. But for now, I think the Kenyan people will be happier if this court can make sure that the authority, their sovereign will, is not taken away. I thank you.
Thank you very much for keeping time. We will take one more before we break for lunch. Petition number E001 of 2022, John Njoroge Kamau.
My lady.
I request for indulgence of the court just to introduce three people I'm appearing with, but they were in the other room, they didn't get access to court. And that is Emmanuel Bitter, Christopher Marwa, and Radhika Arora. I would like to put them on record. Thank you.
Thank you. That is noted.
My lady, Madam Chief Justice, my lady, the Deputy Chief Justice, my lords and my lady of the Supreme Court. I don't believe I need to introduce myself again, since I did that right at the beginning, but all I wish to state is I appear for the petitioner, Mr. John, I'm so sorry, Mr. John Njoroge Kamau, who has been called as a surrogate in some of the affidavits, and unfortunately yesterday was called a proxy. My ladies and my lords, Article 1.1 of the Constitution relates to the sovereignty of the people. Article 3.1 of the Constitution, it is the duty of every Kenyan, and most of us sitting here are Kenyans, to uphold and defend the Constitution. Hence, it is very sad to see that when Wanjiko, or in this case, John Njoroge Kamau, comes to court, he or she is immediately vilified and stigmatized. All he is doing is exercising his constitutional duty and following the law, never wanting to go back to where we went about 15 years ago. And like I said, in social media, everybody gets vilified. We don't need to read social media, as I was told 10 minutes ago. Notwithstanding the same, John Njoroge Kamau, on the 9th of August 2022, in exercise of his constitutional right to vote under Article 38 of the Constitution, went to his polling station to vote for his preferred presidential candidate, and then went home to await the result. It was a long wait for 6 days, but that is not his gripe at all. He is not complaining about the 6 days. As far as he was concerned, he had this legitimate expectation there was going to be a free, fair, credible, accurate, transparent, and verifiable election pursuant to Article 86 of the Constitution. But my poor client, lo and behold, to his shock and horror, at about 4 p.m. on the 15th, a public statement was made by Juliana Cherrera, Irene Masset, Justice Nyangaya, and Francis Wanderi, and I will call them as the 4 commissioners because I won't continue to repeat their names. And in that statement, before the declaration of who he wanted to know was his president, before that declaration, they came out and stated that this election was opaque. Subsequently, at about 6:05, the chairperson of the IEBC declared a result to say who the president-elect of the country was, and this was duly gazetted. To confound it all, on the 16th of August, people started calling, and the 4 commissioners started calling this the Chebukati's results. On the 17th of August, 2022, a statement was issued by the chairperson of the IEBC, and I'm not going to get personal here, I will call him by his title that he's got at the moment, stating the reasons why the 4 commissioners, and the drama continues. My ladies and my lord, this is a voter who is watching all this unfold in public. His simple question is, did my vote matter? Or was it Chebukati's result? Or was it an opaque result? What happened? And that's why that's who I am representing. And I'm very curious for myself. Where did my vote go? Did it go anywhere? Or was it not there? My lords and my ladies and my lords, in order to meet the constitutional threshold of being a credible, transparent, verifiable, accurate process, the electoral process must be conducted in strict compliance of the law. We have filed on behalf of the petitioner very extensive submissions. These were filed on the 26th of August 2022. I am caught in a position where I could sit here and reread everything that's been said or everything that has been reiterated by my learned seniors who are, for once in my life I can say who are much older than me, because normally I'm one of the oldest people in a room, who are much older than me. So I don't wish to repeat everything that they have said, because that we don't have the luxury of time. I will just keep it very, very short, because I am sure your ladyships and your lordships will read the 23-page submissions that we have done. 1. Under Article 138.3c of the Constitution, it specifically states that after counting the votes at a polling station, IEBC shall, it is not say, may, shall tally and verify the count. That's what our framers said. Article 138.310 now starts distinguishing. It says the chairperson of the IEBC. As yesterday was said by Madam Chief Justice, the framers of the Constitution decided to give you 14 days. It's not easy to complete this election petition. It's got to be done within 14 days. The framers of the Constitution knew exactly what they were doing because of where we had come from, culminating in 2007. Hence, the declaration was to be done by the chairperson, but the verification and tallying, if they wanted to do it by the chairperson, they would have said it. Secondly, if, as is being stated by the chairperson of the IEBC, as he's put in his statement that was issued on the 17th of August, it is me. It is me who has to verify and tally pursuant to regulation. There's a regulation 87.3, which my learned friend Mr. Feroz now took your lordships and your ladyships to. I can do it. If he could do it, why wasn't it said? And if he says he can do it, why do you need a commission of 7 people? Why do we spend so much money, taxpayers' money, on a commission of 7 people? Have 3. This court has ruled that 3 people constitute a commission. Have 3. Why do you need 7? Let's take it further. If it's only him, and according to some of the submissions and arguments that are going to be placed before you, the issue of Schedule 5 regarding quorum, and that he doesn't need quorum, it's only in the normal business. My ladies and my lords, what exactly does the IEBC do? Voter registration, but what is its main function related to? Elections. It is all about elections. That's what they do. I don't believe there's been much boundary delineation, but I will stand to be corrected on that by my learned friends on this side. They may know a little more than that. And so, if it is only the chairperson whose argument is, there is 34A, so there is an announcing declaration there, then there is the polling center, and then it comes to him at the tallying center, and he does it. I still go back to 30 billion shillings on an election, and this is what we've got. It's a very sad state of affairs we are in. One man, let's have a commission of 3, going by what he says. Taking it now to the regulations that he relied upon on the 17th, with your lordship's permission, I would state those regulations, unfortunately, when your ladyships and your lordships decided, as my young associates say it in my office, I don't know how they do it, but they say it, Raila and another versus the IEBC of 2017, they claim that according to terminology they use, it's called Raila 2, and then the subsidiary one, the second one that came, when it came for clarification, they call it Raila 2.5. So I don't know why they do that, but that's what the young lawyers do. So I'm going to use their terminology. When Maina Kiai was decided, and this particular Maina Kiai was decided, I believe it was I'd written the date down, but Maina Kiai was decided in June 2017. Subsequently, the chairperson of the IEBC came to your lordships and your ladyships asking for a clarification as to exactly how Maina Kiai was interfering with your decisions in Raila 2. It was so clear on what this court said. And the saddest part is regulation 87 that he is relying upon was not brought to your attention, and from 2017 to 2022, all IEBC does is hold elections but doesn't look at its regulations. And are these regulations, are these going to be the mundane matters that the commission has to decide? Because we've been told, besides verifying and telling, the commission does everything, and those are in their submissions. My lords and my ladies, if you look at my written submissions, and I'm going to take you through them very quickly as to if you look at, and this is, the page numbers are verified, the case numbers, we've put in a bundle of documents. What that statement of the 17th of August said, if you could look at page 8 of my written submissions, at paragraph 19, from about line 18. And this is a quote from the Maina Kiai case. It is, in our view, fallacious and flies in the face of clear principles and values of the Constitution to claim that the chairperson of the appellant can alone, at the tallying center or wherever, purport to confirm, vary, or verify the results alone. This honorable court further said the same thing in the RILA 2.5, which is set out at page 11 of the submissions at the bottom. And you go to page 12, this is at paragraph 20, and it'll be paragraph 292 of the RILA 2.5. The failure by the first respondent, IEBC, to verify the results in consultation with the second respondent, IEBC chairperson, before the latter declared them, therefore went against the expectations of Article 138(3)(3)(c). And there are several quotations I have put in there that show that this court has already made the decision. My biggest fault with the IEBC, and it's not particular the chairperson in himself, for 5 years you did nothing. The Supreme Court told you in October 2017, you can't do this. You do nothing. You amend in April 2017, you leave it at that. There's been hardly any amendments. It doesn't matter who's the Kenyan voter. IEBC, chairperson, we own this. It's an independent commission, but they have to work within the ambit of the Constitution. My ladies and my lord, I'm just going back now. Like I said, I have 15 minutes, and I think I'm going to be at a space where I'm going to be a very patriotic Kenyan, and I'm going to donate the time back to the court, because I don't think I'm going to take the full time to finish my submission, because it's fully set out where we are going to. There are three things that we've brought up. One is the issue of the Regulation 87, which has to be made unconstitutional. And we have relied upon the judgment of this court in the case of Rai, where you declared Section 14, where Parliament went way beyond the ambit of what this court was supposed to do. We are relying upon that to declare that, because it appears IBC is never going to come to you, so we might as well do it once every 5 years to see where they've got it wrong. We're requesting you to declare it unconstitutional. We are going further and stating to your lordships, to your ladyships and your lordships, the issue of the elections, of the cancelled elections. Whilst the elections were cancelled in counties or gubernatorial, and an issue has been taken up that if this court has jurisdiction, because interpretation of the Constitution is in the High Court. My ladies and my lords, Article 101 actually gives a date cast in stone when our elections are going to take place. General Assembly, Parliament, Presidential, the whole lot. So it is on the second Tuesday of every 5th year. Article 101 read with Article 136(2)(a), read with Article 177(1)(a) of the Constitution, and 181, clear, cast in stone. We all know why that happened, because initially dates could be set by whoever they wanted to. And you could have a date on the 29th of December for an election, where voters were available or not available. That was the history of that, in a very narrow way. We now have a situation where elections were cancelled. Today, we have a chairperson and an IEBC who are so disconnected. What happens if in 5 years from now, somebody decides to cancel a presidential election on the basis of a national emergency? This is something that really struck us when we were looking at this. It was something that had never crossed our mind. It's a hypothetical, yes, but maybe some direction needs to be given on that. Secondly, the suppression of voter turnout and voters being disenfranchised. We've been told this entire election is mathematical. Take a calculator and you'll get a result. That's what I've been told. If it's as simple as taking a calculator, the national tally that was stated by the chairperson was 65.4% or thereabouts. In Mombasa, where there was no gubernatorial election, and that you can work out from simple mathematics as to the number of people who showed up vis-a-vis the number of people, the voter turnout was 44%. In Kakamega, with a national tally of 65.4%, the total number of voter turnout was 57%. Simple mathematics, even saying that the figures we have are correct. And that is where we've come from, because there was a submission that we've not shown anything. Those two counties were way below the national tally. Whose strongholds they were is not my problem. All we are saying is that there was suppression and therefore voters were disenfranchised. You're cancelling an election at 8 o'clock at night on the 8th for voters the following day. You can imagine the confusion. And what was the reason for the confusion? A mix-up in ballots. This is all in our petition. I am just speaking to your lordships because if you read the petition, all the annexures are there. Oh, sorry, oops, we made a mistake in the ballot papers. There was a mix-up. Yet, there was supposed to be gazettement. A replying affidavit by the CEO, and it was supposed to be done by the 1st of July, a replying affidavit put in this petition by the CEO. Oh, we gave it to the national printers, the government printers, but they didn't print it, and so it should be deemed as done. There are news articles saying 128 ballots came to this country with ballot papers on the 7th of July, 6 days after this gazettement, or 7 days. And it is quite clear that there was an issue with the gazettement. It was backdated. But 128 ballots were already there. And the chairman admitted it, that there was a problem with the machine at the government printers for the printing. Even if you assume that it was printed on time, it was sent on the 1st of July. The earliest it could have been done was on the 2nd of July, because they haven't given us a time. We are voters, we are just watching this. We're watching this drama unfold. That being the case, and on the 7th, 128 ballots came. That's a lot of ballots and a lot of ballot papers. Nobody checked, like I keep on saying, 30 billion shillings later, we can't get an election right because there's a mix-up in the ballot. And therefore, my ladies and my lords, what is happening here is not a way to have an election at any level. We don't know what is going on as voters. People who are listening to this are getting even more confused as to what is happening out there. Was this accurate? Was this verifiable? It's our humble submission. The commissioners who came out, the disconnect between the commissioners shows that there is a problem. Mr. Chebukati says it is verifiable and accurate. The voter, what does Mr. John Joroge know? The commissioners are saying it was opaque. Where does the voter go? Has everybody forgotten the voter in all of this? The political parties are saying, I won, I won. We want to know what happened to our vote. And where we are today, we actually cannot say that where this vote went and what happened. And in view of that, it's my humble submission that one, the petition be allowed as prayed. And there is a prayer we've requested for, that there should be a nullification of this election, because the sovereign will of the people has not been, well, like I said, what we see, whilst this court says an election is a process, For me, and even as a lawyer, and for Wanjiko and for John Joroge, an election is an event. You're going to the ballot, you're going to cast your vote, and you're hoping that your vote counts. We shouldn't be in a position where we hope that our votes count. We should be in a position where we know our votes count. And whilst there is a prayer which your lordships and ladyships might tell me off about, we have requested that the chairperson be prohibited from conducting any further elections in view of his behavior and or holding any public office in Kenya in breach of Chapter 6 of the Constitution of Kenya. The reason why we've said that is, unfortunately, whilst we created independent offices, we forgot about Chapter 6. And I think this court needs to show the way, even if it's to the lower courts or subordinate courts, show them the way that it's Chapter 6 that is going to be a question of integrity. In view of that, my ladies and my lord, I have nothing to add except if anybody has any questions, and please, can there not be hard questions?
Thank you very much, Council. You have donated to us 7 minutes. Thank you very much.
Thank you
for your generosity. I think we will adjourn.
Is there something about the visitors?
Yeah. 2 o'clock. 2 p.m. Yes. We will adjourn until 2 p.m., but before we do so, I recognize that we have observers who have joined us. Yesterday, during the pre-trial, we formally recognized the observers, but I think they were not present. So on behalf of the Supreme Court, my sister and brother judges and the entire court, we wish to welcome all the observers, especially the delegation from the Commonwealth that is led by our retired Chief Justice from Tanzania, the Honorable Justice Adhman Mohamed Chande, for taking time to come and observe these proceedings. We thank you for taking your time, which is a mark of friendship and also encouragement, and also an indication that we are all pursuing similar objectives of ensuring there is promotion and protection of the rule of law and constitutionalism, and also creation of strong, independent institutions that guard and sustain our democracy. So you're most welcome to the proceedings, and our gratitude for your finding time with eminent judges, jurists, and other distinguished delegates who have committed their time to come and be part of these proceedings. On behalf of the court, we are so grateful. And having said that, I think we will arise and resume at 2 p.m. Thank you.